Yes, I can. Good morning, everyone, and welcome to our first webinar for the year on Labour Law Review. It will be presented by John again. Thank you very much, John. It's much appreciated. Unfortunately, Lisa, our chairperson's mic is not working, so she won't be able to join in the conversation, but you're very welcome to post any chats or questions in the question and answer box or the chat box. So welcome and enjoy. Thank you, John. The floor is yours.
Thank you very much. I appreciate it, and very good morning to you all. This morning, we're going to take a look at all the things that are happening at the moment in the world of labour law. You certainly are in an interesting environment in South Africa, and yeah, some massive changes coming through, colleagues, that you've got to try and figure out what the impact will be on your organizations. I don't believe we've had this amount of legislative change in the labour law space for many, many years. That's probably even the biggest single change that we have had to date. So, colleagues, a very warm welcome to you. I do hope you can hear me okay. My computer seems to be lagging a little bit. I'm not sure why. And then also, Krista, I do want to just confirm again that you can see my slides.
We can see it perfectly. Thank you, John.
Okay, thanks. I'm just trying to find the right screen now with me. Sorry, just give me a second, guys. It's been a blue Monday on a Wednesday. I just want to reshare it. It's good to see some familiar names as well as new names on this particular webinar. So very, very warm welcome to you all. So colleagues, you would have seen the NEDLAC report that was released to Parliament. The NEDLAC report covering a range of amendments to the Employment Equity Act, the BCA, the LRA, and of course the National Minimum Wage Act. So we call it the Labour Law Review, colleagues. That's really what we're going to be focusing on today, the full-on Labour Law Review. And yeah, it's a lot of content. You will get the slides, but do stick with me, because I think all that you should be doing is identifying the areas that you believe are going to be of very, very important significance to you and your clients. So I think for me, one of the big issues is that I see someone said my slides are not showing, Krista. So it is you, in fact, that said my slides are not showing. Let me try and find them again. I don't know why I'm battling like this today. Let's try again. Can you see them now, Krista?
We can see it. Thank you, John.
Cool. Thank you. So let me get straight into it, colleagues. Of course, we are living in unbelievable times. I mean, the rate of change, the depth of change and the consequences of change are just unfathomable. We've barely recovered from COVID-19. I even read an article this morning where the ongoing effects, the lingering effects of COVID-19 on human beings and companies is just still immense. COVID-19 ranks amongst one of the biggest pandemics in the history of the world, given the number of deaths. We've got natural disasters, colleagues. We have fires, we've got flooding. We have significant challenges globally in respect of climate change and all the legislation that comes through that through just energy transition. And what's quite interesting is labor law is trying to come to terms with this. There's even a code of good practice that they're working on now around climate change, because lots of people are being displaced from their traditional sources of energy, like your coal power stations, to your nuclear or your green energy, your solar energy. So you've got this massive disruption to the workforce and the labor market, and labor law needs to come and deal with that. Then you've got geopolitical unrest. Donald Trump alone, with his comments in respect of funding, I've already had a number of clients come to me and saying, John, we now need to start Section 189. We're not sure if we're going to get funding. And, we want to be proactive, because if they close the funding, then we're in trouble. We then have artificial intelligence and robotics. And in my view, colleagues, anyone who thinks that the jobs that are destroyed will be replaced by an equal or greater amount of jobs is not using their common sense. There is no way that the displacement of jobs will be outdone by the creation of new jobs. That's just my personal view, and we can already see it taking place. Many of you would have seen this slide already. I'm not going to spend too much time on it, but I want to ask you the following. Are you going to be a beneficiary of this change, or are you going to be a casualty of this change? Because there are companies that all face the same circumstances. If you look at Checkers 60 or ShopRite Checkers, they face exactly the same circumstances as Pick n Pay. Same customer base, same technology accessibility, same economic circumstances, etc. Yet one of them is really, really doing well, the other one's struggling. We look at the old Nokia versus Samsung story and the digital banking and online banking transition. So it's not a case that some companies are casualties because they are a victim of what's happening. They're casualties because they are not capable of responding appropriately to this environment. And I've been doing a lot of work, colleagues, in the last few weeks and months with companies that have come to me, some significant leaders in their industries and their sectors, saying that they now need to really redesign their organizations. They need to redesign their organizations, firstly, because on the vertical axis, they need to be agile, flexible, resilient, and innovative. You can't be those things if you employ everyone permanently, because you've got a fixed mindset, you've got fixed costs, and everything is a percentage of payroll or percentage of headcount. So companies are saying, John, we now truly, truly realize we need to diversify our workforce modeling. And then on the other scale, on the horizontal scale, we also see the reality, colleagues, that companies are worrying about huge liabilities. We've got massive labor law liabilities. The Employment Equity Amendment Act comes along with still 2% of annual turnover fines. We've got the POPI Act. We've got cyber crimes. We've got new health and safety regulations. So companies are just absolutely pressurized from all angles. So effectively, what I'm seeing and what I'm saying to my clients, they can't employ everyone directly because it just inflates their payroll and fixes their costs and gets the head count. And in this environment over here that I described, you can't go through Section 189 on Section 189 on Section 189 because it's impractical, it's expensive, it creates demotivation. You need to be able to tap into the flexibility of TESs and, of course, subcontracting, outsourcing, and independent contracting. So because this is the procurement world. The benefit of TES, of course, the client still retains operational control over the TES, but there's shared liability. The benefit of independent contracting is that the client gets an invoice and the independent contractor picks up most of the labor law liability. However, the client has to then hand over control, hand over the running of the outcomes, because the client can no longer instruct the labor in these outsourced environments, but has to pay for outcomes. So, colleagues, this particular pattern, of course, in the labor law context, is demonstrated in the next 3 slides. So in this slide, on the left-hand side, you see all the labor laws, and then on the right-hand side, if a customer or a client rather does all of it themselves, if a client goes and just employs everyone directly, the client is liable for everything, as you can see on the right-hand side. If the client uses a TES, well, now you start seeing the green coming in, where the client starts sharing liability with you as the TES. In some areas, there's joint. In some areas, there's several liability. And of course, on top of all of this, the TES procures staff, screens them, assesses them, mobilizes them, manages them from a human resources and labor relations and payroll point of view, and then ultimately demobilizes them. So that entire process is looked after by the TES, which is a massive win for organizations who just get the invoice for that. And then, of course, the final one is if you subcontract and outsource, you subcontract logistics, you subcontract IT, you subcontract cleaning as a fully outsourced service, then your subcontractor is liable for all of that. And this, colleagues, is exactly what is happening in this particular context. So let's take a look at how labor law is driving this process even faster. How's labor law trying to keep up with and modernize to ensure that organizations are going to be sustainable going forward? And I want you to think of your clients. Many of you and many of your clients have been experiencing deep transformational change. So when it comes to labor laws, colleagues, as I indicated to you in terms of labor law, the labor law review process at NEDLAC has been taking place since April 2022. So there's been more than 2 years of negotiations at NEDLAC between business, labor, and government. And those negotiations have been in respect of these 4 laws. And the focus of this has been, firstly, to adapt to labor market changes. So in other words, how do we make things a bit easier for employers? Secondly, what about platform workers? What about on-call workers? What about remote work? So it's about adaptation, trying to support job creation, trying to undo bottlenecks. I mean, the labor court system is clogged. It takes 18 months, if you're lucky, to get to the labor court. The litigious processes, the CCMA is under financial constraints. So they also want to unblock some of the bottlenecks. They want to also look at vulnerable workers. They want to give vulnerable workers, workers that are vulnerable, firstly, because maybe they're on fixed term contracts or they are dependent contractors. I mean, again, your Uber drivers, your Checker 60s, your Dashers, those types of employees, your gig workers. They also want to start trying to find out what level of protection do they need. So this has resulted in 4 amendment bills, and I'm going to take you very quickly through some of these amendments, colleagues. My recommendation is that if you've got questions, that we hold them over to when I just take a break, or you can type it into the chat box. I don't know if you can, but I think let's get going. Write down your questions and we'll try and come back to them. Some of these I'm going to move through very quickly and others I'll take more time on. But the first one, colleagues, is the Essential Services Committee. The Essential Services Committee, as you know, looks at the case of strikes. And if there are strikes, there's got to be at least a minimum complement of staff, because if they're not at work, it could result in the loss of life, in the loss of property and assets. So the Essential Services Commission, they are trying to give it more support because it's very ineffective. They're trying to give it more support from the CCMA in terms of financial support, administrative support, and they're trying to get organizations that believe that they need minimum services agreements to enter into that. So here where you see the green, that was agreed to by business, labor, and government. In other words, to give more expediency and more resources to that commission. This is an interesting one, colleagues. Bargaining councils, if we take a look at that, secret ballots by trade unions to determine the continuation of closed shop agreements lapse after 3 years. So if there is a company with a closed shop agreement, and you remember what that means, is that employees are not allowed to join another union. They've got to join that particular union, and they've got to contribute and become members of that particular framework. Even if they don't join the union, they've got to pay their dues, and that those monies are used for other purposes. So instead of this being an indefinite arrangement, that agreement closes or ends after 3 years. So trade unions that want to continue their closed shop arrangements will have to go through that. Also very important, colleagues, also very important is the issue in respect of is the issue in respect of trade unions, the minister being able to publish guidelines for cancelling trade union or employer organization registrations. If you've been following the government gazettes, there have been a huge amount of deregistrations of trade unions for various reasons, including they don't have their financials up to date. And you can see the last point, they want trade unions to become more good corporate citizens with their governance, and especially financial governance under the Companies Act, to improve. So you can expect trade unions to be under the spotlight a lot more than they used to when it comes to these issues. That was agreed by business, labor, and by government. Unfair dismissal remedies. Now, colleagues, I need you to listen to this very important proposal. Now, all these proposals I'm talking to you about are probably going to come through in Q3 or Q4 of this year. They're busy going through Parliament now. They've come through NEDLAC. They're going into Parliament. So the first thing is, if we look at the unfair dismissals, what they're saying is highly paid employees, and they define highly paid. Look at the last bullet point, 1.8 million rand per annum. So if you look at people earning more than 1.8 million rand per annum, colleagues, if that is someone, they have got limited protection for unfair dismissal. What does that mean? Well, let's say you fired someone who earned above 1.8 million and they challenged their dismissal at the CCMA, and the company was found to have unfairly dismissed them. They can only get maximum 12-month salaries, which is 1.8 million. So if you earn 4 million, you won't get 4 million rand for 12-month salary. It's capped at 1.8 million, which is very, very important. And also there's no reinstatement right. So people earning more than 1.8 million, the company doesn't need to reinstate them. It's not an option for high-paid employees. So it's interesting. They're saying if you earn above that, you should be negotiating your own employment contracts and your own well-being. Don't rely on massive payouts from the particular CCMA, etc., and the arbitrators or the labor courts. Colleagues, this is very, very, very important, because I'm going to come back to this later when we talk about the Code of Good Practice on dismissal. Now, all of you on this call know that dismissals have been very, very formal to date in South Africa. It's almost like a criminal process: pleading of guilt, evidence in chief, cross-examination, re-examination, mitigation, aggravation, etc. And then, of course, a very detailed finding and what have you. The proposed dismissal procedures and the changes are: employees need a fair and reasonable opportunity to respond. Okay, so you'll see when we get to the code on dismissal, they're trying to decriminalize this and make it easier and more expedient. This is extremely, extremely interesting. A qualifying period during which new employees would have limited protection against unfair dismissal. And this qualifying period, they want to set it at 3 months of employment. So basically, colleagues, in the first 3 months of employment, if this goes through Parliament, you will have no unfair dismissal liabilities towards employees. The only time in the first 3 months employees will be able to litigate against you is if you are guilty of automatically unfair dismissals, such as dismissing because of race, gender, sex, culture, language, etc. So, colleagues, very, very important. Here you can see that they're trying to free up employers and encourage them to employ more people. Now, in your context, the question is, how are you going to use this opportunity as part of your value proposition? You can also see in the Code of Practice for Dismissal, they are looking at longer probation periods. So there's even a possibility of extending the 3 months to maybe even up to 6 months. Interestingly, Labour and government agreed to a 3-month period, but business wanted a longer period. So it's interesting to see that even Labour, the unions even, understand the need for employment creation, taking away a bit of red tape, at least in the first 3 months of employment. So that's very, very interesting. Colleagues, the proposed amendments to the LRA also and include companies being encouraged to use pre-dismissal arbitration, and they allowing you to write it into your employment contracts. So in other words, if you look at an employment contract, you'll be able to have a clause in there saying that the parties agree that if it's a dismissible offence, that an external party like a commissioner will be able to come and chair the inquiry, and it then has the status of an arbitration award. Why are they doing this? They're trying to free up the CCMA systems by bringing it in-house, but to give it the same gravity as a arbitration award. Well, we're talking about change and agility and flexibility. Look at what the trade unions tried to do here at NEDLAC. The trade unions try to extend the period of consultation from 60 to 120 days for Section 189 capital A. So the trade unions were trying to make it more difficult and take longer for companies to retrench effectively by doubling the consultative period. Can you imagine, colleagues, under these volatile and uncertain conditions, if you had to consult for 120 days, 4 months, and then they wanted to also increase severance pay to 2 weeks severance pay per completed year of service. So now, colleagues, the bottom line is you'll see business have not agreed to the extension of the period from 60 to 120 days. So that's not going to happen. But as you are aware, the bottom line is they are going to probably come up with 2 weeks per completed year in respect of severance pay. And here we have it. Severance pay, Labour and government agreed, but business disagreed. 2 weeks pay, but it does not apply retrospectively. It only applies prospectively going forward. So this is important in your context, colleagues, because many of you have got temporary assignees who've been working for even a decade or even longer than a decade. Now, suddenly you might have to remove them, and severance pay comes into the picture, potentially as a Section 189. So you're going to have to contract very carefully with your clients around who pays for the severance pay. And secondly, the 2 weeks will only kick in after this amendment has been approved. In terms of unfair labor practices, and you'll remember, colleagues, in Section 186, look at the first bullet point, promotion, demotion, probation, training, and benefits. Those were all grounds on which you could refer an unfair labour practice to the CCMA. What they are proposing, and you can see business and government have agreed, the unions have disagreed, but they want to restrict unfair labour practices only, firstly, to unfair suspensions. In other words, you suspended pending a disciplinary inquiry in a manner that's unfair, like you don't have a paid suspension. Secondly, disciplinary action short of dismissal, so a final warning, a written warning, and then protected disclosures and whistleblowing. They want to take out disputes about promotion, demotion, probation, training, and benefits. So it's interesting. It's very interesting. Can you imagine employees not being able to refer disputes about those matters? So the CCMA is saying we want to free up our systems, we want less litigation, and what we need, colleagues, is we need people to only focus on the big ticket items like disciplinary action, suspension, and protected disclosures. So I don't know what your thinking is, but for me, it's very, very interesting that even Department of Labor are siding with business in many of these areas, which is absolutely unusual. Normally at NEDLAC, business is isolated because labor and government stand together. But now you can see the pressure on government. And I think the government of national unity has also had an impact where they're starting to say the legislative reforms have to take place to keep South Africa competitive to some extent. You've also seen the World Bank telling our Minister of Finance that we need to start relaxing onerous labor laws and, in certain instances, other laws. Well, let's look at your environment, specifically temporary employment services. So Johnny Goldberg, who leads the delegation at NEDLAC, he tried to extend Section 198, the deeming provision, to 6 months. In other words, that only after 6 months for people earning below the threshold, the client becomes the deemed employer. Government initially agreed to that, colleagues, because it's currently 3 months. Okay. And government initially agreed with business, and then I think there must have been massive pressure from the unions on the Department of Labor, and then government withdrew the agreement. So it's still going to be 3 months, but business did try and deal with that. Then if we look at socio-economic protest action, it was an absolute joke because trade unions could go to NEDLAC and register a dispute, for example, around load shedding, a dispute around the economy, the poor employment conditions, and then go on stayaways under Section 77 up to 7 or 8 years later. So even this COSATU strike that's coming up in the next few days was originally lodged in 2017 or 18, but they've now decided they want to go on strike about it. So the new provisions will be that once they've registered a socio-economic interest dispute, they've got to go on a national stay away within 24 months of registering that dispute. So Labour and government agreed, business disagreed. Business said that should be shorter, 12 months, but they are going to limit that. I'm going to come back to this next slide just now, colleagues, because it talks about the code of practice on dismissal. And this is a big one for you. I'm going to take you through that in detail, but I want you to start thinking about your disciplinary codes and your disciplinary procedures. And I want you to think about that in the context of your clients, because I'm not sure what you currently do. Do you have your own disciplinary code and procedure that applies to your assignees for the first 3 months if they earn below the threshold, and then after 3 months, does the client's disciplinary code apply? Or alternatively, do you align directly from day one with your client's disciplinary code? This is going to be a big, big, big point of discussion, and I'm going to come back to that towards the end of today. Well, we've taken a look at a whole range of Labour Relations Act amendments around the definitions, not the definitions, the types of dismissal. We've taken a look at socioeconomic action, people earning high salaries and the limiting of their awards, we now move into the world of the Basic Conditions of Employment Act and related areas. Now, the definition of employee, colleagues, the labor movement, the unions, COSATU, NACTU, and FEDUSA, the trade unions, they wanted the definition of employee to be broadened across all labor legislation to extend to current workers lacking protection. So they wanted to extend the BCA, the LRA, the Equity Act, the Skills Act, UIF, Workmen's Comp, SDL, all that legislation to not only include the current definition of employees, but vulnerable workers like Uber drivers, like Checker 60, like gig workers in certain instances. And fortunately, as you can see in green, business disagreed. Business said you can't go and change the definition of employee across all legislation. It's too complex. How do you get an Uber driver to contribute to UIF or workman's comp? How do you process their claims, etc., etc.? How do you report on employment equity? It's going to be a dog's breakfast. So the outcome was to extend only the right of freedom of association and bargaining to broader categories. So what we are seeing is going to happen potentially is that your vulnerable workers won't be able to be beneficiaries of traditional labor law, but they can join trade unions. They can become part of trade unions. Isn't that interesting? And as you can see, a business have disagreed with that. They're saying, how can those people, those workers who are not employees in terms of the broad definition necessarily, some believe they are employees, others not, but how can they have access to freedom of association when they're not de facto employees? So we'll have to watch that closely, colleagues. Well, if you've fallen asleep and you've had too much of a information overload, now's the time you need to wake up. This is a massive, massive change, colleagues, coming through, having an impact on your industry and on your clients. They've called it in the BCA amendments on-call workers or zero-hour employment arrangements. So what does that mean? What is an on-call worker or a zero-hour employee? Well, colleagues, this applies to employees who work only when the employer makes work available, and those employees must then make themselves available to accept such work. So if you think of it, your fixed term contracts say that, John, we are a TES. Some days you're going to work full day, some days you're going to work part day, and some days you're not going to work at all, right? So I am an on-call worker. I'm not guaranteed hours. It's a 0-hour agreement. Now the BCA is going to come and in a lot of detail start making it compulsory to expand your terms and conditions in your contract of employment, your fixed term contract. So what happens is, and I'm just giving you some highlights, under the amendments, you're going to have to include a paragraph on what are the minimum guaranteed hours, if any. What are the maximum possible hours that these people would work? What period must these assignees be available for? In other words, even though they're not assigned, they're on call or they're 0-hour workers. They've signed an FTC, but they've not yet been put on an assignment. So you've got to then limit that period and then renew that baseline fixed term contract. You then have to also write in the notice period for calling them into work. So you're going to write into the contract, say, John agrees that 2 hours notice is sufficient in order to call John into work. But you've also then got to have a notice period for cancellation. So in your fixed term contracts, you're going to have to say that we reserve the right to cancel the assignment that we have promised you for tomorrow within a certain notice period. But if you breach that notice period, you're going to have to pay a minimum of a certain amount of number of hours. So for example, if you're expecting a massive shipment to come in, a big delivery, your client phones you and says, I need 10 forklift drivers and I need 40 pickers and packers tomorrow morning at 6 o'clock. If that particular load and those goods do not arrive overnight, you're going to have to give the notice period and cancel that with those assignees. If you don't cancel it within the requisite period, then you're going to have to pay a penalty to those particular assignees. So colleagues, this is a massive change. You can see business have disagreed with it, but Labour and government are saying that on-call and zero-hour workers are not treated fairly. And therefore, they are saying they're going to expand your requirements. So your entire fixed term contract is going to have to change. And you also, of course, by implication, your service level agreements with your clients are going to have to change because, you're going to have to mirror your FTC with your SLA and vice versa. So your client's going to have to be told you can't cancel a particular request within 2 hours of the actual, time that the worker was meant to arrive, or else there's going to be some form of penalty that will have to be paid. So you can see on the screens, colleagues, you're going to have to cancel with proper notice. You can't place assignees on assignment if you haven't complied with all of these written contractual requirements. You also can't prevent those 0 hours and on-call workers from working elsewhere, with a few exceptions. And then, colleagues, right at the bottom, if there are disputes, they will be dealt with under Section 198D. So I've included in the slides just some further details in terms of on-call and zero-hour workers. Take a look at it. I've looked at some of the potential impacts that might have on yourselves as temporary employment services. And colleagues, let me just take a breath and remind you, where are we with all of these things? This has come through NEDLAC. That's why, as you see in the bottom, there's a report and it says, what have business, labour and government agreed on? What have they disagreed on? This report has now been referred to Parliament. Parliament have to now take this to the Portfolio Committee, then to National Assembly and the National Council of Provinces, and eventually it will come out. And we are expecting, based on what I've been told, Q3 to Q4 of this year. So you need to now go and look at the stuff. It's probably going to remain very similar and say, what will you need to do to realign to these provisions? Well, if we take a look at some more labour law reforms, very briefly, picketing rules going to become a lot clearer, in terms of strikes and the accompanying picketing rules. And also, colleagues, look at the second bullet point, the CCMA's authority to handle disputes under various laws. So you're going to see, for example, if there are two referrals, an unfair dismissal and an unfair discrimination claim, but the same parties are involved, they're going to enjoin those processes rather than have two separate processes. Labour inspectors that come and issue you with compliance orders, if you want to challenge it, you're going to end up at arbitration. So they're trying to enhance efficiencies and they're trying to enhance dispute resolution. And look at the second last bullet point. The CCMA will deal with automatically unfair dismissals for employees earning below the threshold. In other words, automatically unfair dismissals traditionally would go conciliation, then to the Labour Court and take 18 months. They're saying that's not fair. People earning below the threshold are more vulnerable, and their matters must go to arbitration and not to the Labour Court. So I hope you're finding this interesting. And then also under the Employment Equity Act, the same principle, colleagues, any harassment claims, any form of harassment can go to arbitration at the CCMA. Not just sexual harassment, as is currently the case. So they want any harassment claims, be it things like constant criticism, abusive language, joking at someone's expense. All 18 types of harassment will now no longer go conciliation labor court, but conciliation arbitration. This is a big, big, big liability for companies, because if they're found guilty, remember, they can then also lose their certificate of compliance under the Employment Equity Act. If you found guilty in the previous 12 months before you submit your employment equity report of any form of unfair discrimination, including harassment, you won't get your certificate of compliance. So companies are going to have to, including you're going to have to make sure that your grievance procedures, your harassment awareness programs, and any form of harassment is given priority. Because if it lands in the hands of the CCMA and ultimately on review or on appeal to the Labour Court, you're in trouble. And not only you, Section 57 of the Employment Equity Act says, if you act on a discriminatory instruction of the client, then you are jointly and severally liable with your client. So colleagues, you need to make sure you're doing everything you can. You need a proper harassment policy, awareness creation, and then you need to give your assignees a clear channel to report any form of harassment by any party. Very, very important. The CCMA is also going to have expanded jurisdiction to cover severance pay claims, condonation applications, and appeals against the labour inspectors, and then, as I said, to consolidate claims, even if they're across different statutes. So if you've got a BCA matter and an unfair dismissal, they'll enjoin them and pull them together. And then also they're going to clarify the processes for fining if there's non-compliance. Well, colleagues, what about non-child-bearing parents? The Van Wyk case, you remember, said that it is unfair discrimination not to allow a non-child-bearing parent access to 4 months leave. Not only the non-child-bearing parent, but with adoption, as well as with commissioning surrogacy agreements. So the bottom line, colleagues, is that that we are waiting for the Constitutional Court to proclaim and to confirm the High Court judgment. As you can see in the second bullet point, the Constitutional Court met on the 1st of November last year, and we are now waiting any day now for a ruling in this regard. What will the ruling say? It will say that if you're a non-childbearing parent, an adoptive parent, or a commissioning surrogate parent, it doesn't matter whether the one partner or the other partner takes leave or both together. They are both entitled to a maximum of 4 months split between them. Not 4 months for one and 4 months for the other, but between them they can decide how they want to use that 4-month period. Now, of course, if you have got any payment policies, if you're paying your current female employees who go on maternity leave all or part of their salary, you're going to have to review that very quickly, because once this judgment comes out, you're going to have to extend that payment, colleagues, to adoption, commissioning surrogacy, and non-child-bearing parents. Well, the national minimum wage increased on the 1st of March, as we all know, increased by 4.4%. And colleagues, the big issue was the Quantum Foods judgment. Now, the Quantum Foods judgment in the Labour Appeal Court said, when you're looking at the national minimum wage, which is now 28 Rand 79, if you want to see how to calculate that, the Labour Appeal Court said you can look at the basic salary plus employer contributions to pension funds, provident funds, etc., as well as any guaranteed bonuses like 13th checks. So the Labour Appeal Court took quite a liberal view, and they said, well, to get to 28 Rand 79, you can add all of that together. Of course, the trade unions, as you can see in green and government, at NEDLAC, they said, we don't like that judgment because the national minimum wage should be just the wage, not including employer contributions to funds, and not including guaranteed bonuses. So they've now proposed an amendment to the National Minimum Wage Act that they only have 28.79 rand. That's the base hourly rate. And you cannot include those other contributions. So what I'm saying to my clients in this regard, when they are subject to the national minimum wage, I'm saying to them, if you are currently paying a 13th check, rather bring that into your monthly salaries. So instead of paying a 30th check in December, divide that salary by 8.33 and put it into every month so that you're enhancing your national minimum wage and it's not a deferred payment. Because if this judgment comes through and they make this amendment, colleagues, what then happens is you're going to get wage inflation because companies are going to have to pay their contributions and incentives over and above. So this was just a summary of the national minimum wage in the Quantum Foods case, where the court said that contractual bonuses and employer contributions to funds can be included. So the amendment to the national minimum wage will undo that going forward. Just for interest's sake, I've also come across some companies that have commission earners only. So like call centers and sales workers, sometimes they get paid per sale or per deal or per whatever they are doing. And then sometimes they end up getting paid less than the national minimum wage because maybe they haven't sold policies or they haven't sold products. And that is not allowed. Very, very clear clarification in respect of commission-only earners. If you paid on commission, you still have to receive the minimum wage. You can't say, John, you only sold 5 policies times 200 rand, it's 1,000 rand. You've still got to pay, John, based on the number of hours at 28 rand 79. Very, very important in terms of commission only workers. Well, as I said, they're trying to stimulate the economy to some extent. One of the proposed changes to statute, and this will affect many of you working with bargaining councils, new employers with less than 50 employees will be excluded from collective agreements in bargaining councils for 2 years. So if you've got startup businesses under 50 staff, for 2 years, they won't have to comply with that collective agreement in the bargaining council. Obviously, you can't now go and, undo your business and unbundle it and go and start new businesses and say, well, we are not going to comply. Well, colleagues, we've been through this. We've spoken about the proposed change in the definition to employee. Quite interestingly, they're saying that this definition, they're saying an employee should include someone who works personally for another person. So if you think, for example, of an Uber driver or a Checker 60 delivery driver or a Dash, or even someone who's in your IT contracting space, if they're working personally for a company, another legal entity, well, they want to expand the definition of employee to include them. And if they are not serving clients or customers of their own. So they're working only for one organization. Now, the impact of that is to broaden the protection to platform workers and to gig workers where they are only working for one other company. So the control test and the organizational and those tests still remain. But what they want to do is they want to try and augment that. They want to start becoming clearer in terms of these new forms of work that are emerging. And I've been warning platform workers companies for years now saying, are you sure that your drivers, that your scooter drivers, are you sure that your platform workers are truly independent contractors? Are you sure paying them per delivery does not conflict with the provisions of labor law? And these amendments to the BCA are going to make it even more specific and say if they're only working for one other person, they're not serving their own other clients, they're deriving most of the well-being from that particular organization, well, then that organization will be their employer. Well, colleagues, gig economy, national, non-traditional works, they're trying to prevent the misclassification of employees as independent contractors. Well, let's summarize all of this. If it was a mouthful, I'll forgive you because it is a mouthful. But let's just summarize which of these labor law review amendments are beneficial to employers. Well, I've listed them over here for you. The fact that highly paid employees, more than 1.8 million, the fact that they have got limited compensation to 1.8 million, and no reinstatement rights, that is beneficial to employers because we all know the toxicity and the culture of the business is affected by the leaders of that business. And here the courts or the drafters are saying companies should not have to take back and reinstate highly paid workers if they don't want them back. And secondly, people that earn 10, 20, 30 million rand a year should not be entitled to those big payouts for unfair dismissals. They should be capped at 1.8 million rand. The other benefit for employers, as I said, was a 3-month qualifying period with basically no unfair dismissal protection. That's a massive win. I think your working interviews are going to come back with a vengeance, and I think organizations are going to sort of really use that working interview, to a large extent. Pre-dismissal arbitration, they want you to please consider, rather than referring matters to the CCMA and bargaining councils, rather have a pre-dismissal arbitrator in-house, and they unclog the system, and then you also get a faster resolution of your disputes. Exemption of startup businesses for 2 years, under 50 employees from bargaining councils. Section 198A, of course, as I said, they are wanting to make it a bit more longer in terms of consultation. I don't think they're going to get it right. I think it will stay at 60 days. And they're also going to make it more clear in terms of retrenchment processes. So they're going to codify that and make it clearer. Before you go on strike, they're going to need strike ballot requirements, which means trade unions are not going to be able to go on wildcat strikes as much as they used to. They won't have as much protection. And then, of course, Section 77, 2 years, 24 months within which to go on your stay away. What are the challenges? What are the negatives of all of these changes? Well, the first one is they want to expand the definition of employee. So remember what I said? They want to expand it to include workers, not employees, but workers who only work for one primary company, not their own clients. So that's got a big impact on platform workers. It's also going to be addressed in the Employment Services Amendment Act, which is at NEDLAC. Then severance pay increased from 1 to 2 weeks going forward. On-call workers, all the contractual changes. I mean, imagine your fixed-term contracts covering all of the detail that I spoke to you about earlier and how to administer that. And that's a great opportunity for you because I can guarantee your clients will not have the systems and the processes to manage those new on-call worker protections themselves. So there's a great opportunity for you to take that pain away from them. Freedom of association to be extended also to non-direct workers, dependent contractors, and then the definition of the national minimum wage to change. I quickly want to end off before we maybe open up for Q&A. I want to talk about the Code of Good Practice on dismissal and go back to that very colorful slide that I had earlier, this slide over here. Now, colleagues, the Code of Good Practice on dismissal has been published for commentary for 60 days. It was published about a month ago, so we are probably in the last 30 days of commentary. But I'm just going to share with you at a high level what this Code of Good Practice on Dismissal covers. Now, firstly, if you take a look at this matrix, you'll see, colleagues, the first thing is that it is a lot more clear. And it's clear in that it's saying it provides guidance on your legal obligations. So it's not as prescriptive as the current Schedule 8 of the LRA. You know, the wording is more about this is a guideline. Obviously, you've got to engage in fair labor practices, but employees need employment justice and companies need to be sustainable. But the wording is a bit lighter. The next one is small business. Now, they don't define small businesses, which is very interesting in this code on dismissal. They just say that your business might be small because it doesn't have a human resources department of any significance, doesn't have the resources, the knowledge, the expertise of labor law. So small businesses, colleagues, are going to be given a lot more latitude. Small businesses are going to be given the opportunity to do away with things like 48 hours notice pending a disciplinary inquiry because you suspend on full pay. Now they're paying this person, then they don't arrive after 48 hours, and then you postpone, etc. So small businesses, in my personal view, are literally going to end up, if they're clever, having same-day dismissals. You're going to do away with all the written correspondence and the notice to attend and all this stuff. So small businesses are going to have a wonderful opportunity to revisit their disciplinary codes and procedures. Then, colleagues, I go into the definition of dismissal. Now, all of you know that Schedule 8 talks about dismissal, and mainly dismissal, for two reasons: misconduct and incapacity. So when we talk about misconduct and incapacity, the obvious thing missing is operational requirements. Look at the dark orange at the bottom. So they've now brought Section 189 requirements into the Code of Good Practice as well to cover all three types of dismissal: misconduct, incapacity, and operational requirements. So they are all housed in one place. And what's really interesting, if you look at the operational requirements section, colleagues, then you will see they've even given you a template, a table, showing you what should be in a Section 189, subsection 3, notice to attend a disciplinary inquiry. So very interesting how the Department of Employment and Labor are trying to simplify and expedite and decriminalize these processes and give more guidance and make it easier for smaller business. Another big change, colleagues, is if you look at incapacity, they've also included under incapacity not only ill health and poor performance, but they have also included incapacity to cover two new areas. The first new area is how to deal with incarceration. In other words, employees that are locked up in prison, pending bail or pending their day in court, or even thereafter. So incapacity now includes incarceration and it includes incompatibility. Now, incompatibility, of course, is a very interesting concept because it doesn't talk about poor performance because you're not, meeting your quantitative goals. Incompatibility talks about a difference in values, a difference in culture, and the intangible aspects. And the Code of Good Practice on Dismissal is now saying you are fully within your rights to take incapacity procedures against people who just don't fit in with your company. They're a square peg in a round hole. You're a high performance company and they are not high performance focused. They're more built for comfort rather than speed. You're a company that values loyalty, but they are always on their own, isolating themselves and doing other stuff. That has now been put within this particular framework. So, colleagues, that in essence covers the labour law review that is taking place. So to recap, before we open for questions or comments, to recap just a few key areas in case you joined late. The first thing I want to do is to say these matters have been at NEDLAC for 2 years. They've now been concluded. A report has been referred to Parliament, and we believe that the outcome, the final amendments to the BCA, the LRA, the Equity Act, and the National Minimum Wage Act will come into effect in Q3 or Q4. The Code of Good Practice on Dismissal, that will be finalized. There's still about 30 days of commentary left, and that will then become available probably towards the end of April, early May. In other words, colleagues, you are going to have to go and ask yourself, in terms of the Code of Practice on Dismissal, in terms of the decriminalization of the process, in other words, how long you suspend for pending the outcome of inquiry, proper prior notice, the formality with which you chair inquiries, all those things. You are going to go and take a look at your disciplinary code and say, how do we make it more agile, and how do we make it cheaper, and how do we make it less criminalized, so that you don't end up in a disciplinary with those long, drawn-out processes. The CCMA will also become a bit more lenient in respect of procedural fairness, because it won't require you to now follow all these detailed processes. All they'll want to know is, did you provide the employee with an opportunity to be heard? Did you provide the employee with an opportunity to present evidence, and did you consider their particular input? So that's effectively where we're at. I think for you, the question is, how do you respond to all of this? Obviously, you need to go and digest it. And Krista, maybe as a follow-up to this at some point, we can maybe talk about, okay, you've now had a month or two to reflect on some of these changes, and maybe we can get into some more specific areas. I see there are questions. Krista, if it's okay with you, I'll quickly go through that, and then we can open up for any further questions. Is that okay?
Sure. Go ahead, John. Welcome.
Great. Thank you. Right. Someone said they can't hear the presenter. I hope that they did eventually hear that. It will absolutely kill me if I had to go through all of that again. Will the 2 weeks packages per completed year be extended to fixed-term employees who exceed 24 months service? That's a very good question. So we know that currently the LRA says if someone's on an FTC beyond 24 months, you pay them termination pay, 1 week's termination pay per completed year of service. So the answer to this is no, because termination pay is different to severance pay. Severance pay will only apply if it's off the back of a Section 189 process. But if it's, let's say someone's constructing a new Gautrain extension, it takes 3 years, it's always been a fixed term contract, and after 3 years, the contract's over, you're only going to pay 3 weeks termination pay. You don't pay severance pay. But let's say that whilst you're on the contract, for some reason, they don't need as many people as they thought, and you now have to be removed. You apply Section 189, then you will have to pay 2 weeks per completed year. So colleagues, those are the only questions in the chat box. Either you've grasped everything and you're on top of it, or you need to digest this in a bit more detail. But if you want to unmute, colleagues, here's your opportunity. Maybe we can also talk about any questions you have, maybe on the employment equity, what to expect over the next month or two, etc. But Krista, I'm in your hands.
Thank you very much, John. As always, very informative. And I think it's really some food for thought and to be digested. It'll probably take a while, and we'll take you up on the follow-up webinar regarding this. I just want to see and test if Lisa's mic is working.
Good morning, Krista. Good morning, John and everybody. Yes, it is. John, I would just like to thank you for your insightful presentation today. We truly appreciate this time and the expertise that you've shared with us regarding the NEDLAC Labour Law Review. This deep dive, which was really, really deep into the key amendments and the implications for both us, the employers, as well as the workers, has been really invaluable. As we've seen and understand the balance between the employer's flexibility and the workers' protection, it is essential for these changes that takes effect. To the knowledge gained from this session, we will certainly help our TESD members to navigate the upcoming legislative adjustments with greater clarity and confidence. On behalf of the TESD and the members, I would like to extend a sincere thanks to you, John, for guiding us through this complex topics. And we are looking forward to the webinars to be announced for the rest of 2025, which Krista will announce with the members as we schedule the dates, and where you will continue to navigate employers and the TES companies through the ever-changing labour markets. So yeah, thank you once again, and we wish you a great day ahead.
Thank you so much, and I appreciate you always inviting me back. And as you said, Lisa, I know it's a very deep dive. It's not about grasping all the detail. I think it's about looking at opportunities now already that you can go and delve into. And then, as Krista said, maybe we can look at some core topics. So maybe in future, we'll look at the disciplinary codes and what options you have to make it more agile, and maybe aspects of contracting. But thank you very much for the opportunity, and have a super day.
For
Thanks,
sure.
John. Thanks to all the members. Thanks,
Krista, you will share this with all the members afterwards.
Yes, the link.
Thanks.
Yes,
Thank you, everybody, for joining us. Have a great day further.
Thank you. Have a good day.